Judge Karen fought for her client's rights. She was elected to the bench because she believes in doing the right thing.
I'm very passionate about helping people, period. Sometimes life pulls you from up here to down here to teach you a lesson. And you're in a valley right now. There are lessons in this valley. I hope you learn from them.
Objective, independent justice.
You can always turn your life around. If you keep walking, you can overcome whatever circumstances you're facing.
This is Supreme Justice with Judge Karen. Raphael McGee is suing college student Ashley Winfield in the amount of $820. He claims the defendant posted his private photos intended for a private project.
All parties have been sworn in, Your Honor.
Thank you, Shane. You may be seated. All right, Mr. McGee, you are suing Ms. Winfield for breach of contract in the amount of $820. Is that right?
That's correct, Your Honor.
Okay, and you're a photographer?
Yeah, just graduated.
Graduated from what?
Photography school.
Photography school. And how do you know this lady?
We met through a mutual friend. I needed a model for a shoot that I was doing for a coffee table book.
Okay.
And she recommended Ashley. Yeah.
Miss Ashley, so you're a model?
No, this is my first photo shoot that I've done.
Okay. So it was a first for both of you? First photo shoot for you? Are you an aspiring model?
Yes.
Oh, okay. And you're an aspiring photographer,
Yeah.
so it was a nice little match, huh?
Well, yeah. Well, no, not exactly anymore. No. It was nice at the start, but
Right.
then...
What happened?
What happened was, well, we had a great thing going.
Right.
She took brilliant photos.
Right. Where'd you use? You have a studio or what?
I rented out a space.
You were okay.
Rented out a space. I had some people help me,
Right.
friends from school.
So what were you trying to do? Create a portfolio?
Oh, it's a coffee table book. It's like a first.
Oh, yeah, you said that, didn't you?
Huh?
Yeah, you said.
Yeah. And it's a way to get really my work out in the professional realm.
Well, what's the coffee table book about?
It's just like kind of life at the college, college life with students and everything. Kind of.
So why did you need a model?
Well, she's actually goes to the school that I graduated. She's still in school.
Oh, I see what you're saying.
And that's how we met through that friend.
Okay.
Yeah.
So we rented out space. We took some pictures.
Took some pictures. They were great.
Right.
I showed her some of the pictures on an email saying, well done, great, this is what they looked like.
Right.
But then she posted them on social media out into the public.
Right.
When that breached the contract.
It was a non-exclusive contract.
Okay.
No.
Well,
no.
Is there a copy of the contract?
I have all the evidence.
I have one.
Okay. Well, it's the same thing, isn't it?
Yes.
Okay, let me see yours. You're the plaintiff, so the burden's on you anyway. So let's see what you got.
It says
all rights are reserved to me and all the pictures.
Okay.
I gave her a couple copies. I showed her the pictures on an email, but it still says she's not allowed to share these until the book is published.
That's not true.
They still belong to me.
So did
you never said that I couldn't use the pictures.
Yes, I did. I said you could use them after I published my book.
You want to talk to each other and let me know when you're ready to talk to me? Because I could go back out.
No, I'm ready to talk to you.
So why do you feel you had the right to just publish these pictures?
Well, it wasn't exclusive.
Okay, so what does the contract say?
It says it's non-exclusive. It says that he can use the pictures and so can I.
It does not say that. It says that I'm allowed to use the pictures in any media form that I so choose, except for certain ones that are, pornography, whatever.
Well, these are some nice pictures. Let me just say that.
Thank you very much.
You did a very good job of capturing her.
The thing is, I can't use them anymore for the coffee table book. Now that everyone has seen them online, it's all just tarnished.
Okay, so let me read your contract.
Okay.
I agree. This is you, Ashley. I agree that I have no rights to the images, and all the rights to the images and all the rights to the images taken belong to the photographer and his assigns.
Right, but he said I could use it for my portfolio.
After it was published, that's what I said. You broke that contract. Now you owe me the money for the whole shoot. That's how it runs. I have to redo the entire shoot. I have to get a new model and I have to restart. Get the location, buy more catering, get the crew together again so I can restart the whole thing. I have $5,000 invested in this whole project already, and this back step is going to cost a lot more than what I'm suing her for.
Okay, I don't understand from this form where you think you had a right to publish them.
Thank you.
The man was taking pictures of you because he wanted to publish them. So I don't see where you thought...
Well, it's non-exclusive.
I don't know what you're talking about, non-exclusive. It says right here, I agree that these don't belong to me, that they belong to him. And why did you show them to her?
I wanted to just show her that she did a good job. She's a new model.
that I
She's
just
probably-
Let me just
use
say
them.
this to you. There's a way to get those pictures out to people. They have that watermark that you put over images, because let me tell you, I took some fabulous pictures at my book signing. And when I asked the photographer if I could see them, he sent them to me by email, but they had a big watermark across them so I couldn't use them.
Right.
And see, this is your first foray out into this. I don't need an amen corn over here.
I'm sorry.
This is your first foray out into this industry, but this is like a learning lesson here.
Well-
Is that if you're going to send somebody something by email and attach a picture, you basically are asking for trouble. And even though I see this agreement that you have, it says, I agree that I have no rights to the images. Well, all she did was put them on her social media page.
Well, as soon as she did,
I mean, she wasn't selling them. And if you didn't want her to do that, you should have had watermarks across them. Because guess what? She could have shared it with her mother.
Coming up on Supreme Justice with Judge Karen.
well, it's about I have to retake the whole shoot again. I can't use her pictures anymore.
Right? Do you want to use her anymore?
I don't want to use her anymore.
Oh, so you're through with her too?
I'm through with her.
And later,
You tell me that this animal actually jumped over the fence.
Yes. Yes, sir.
That's what I have a problem
Yes.
with. The fact that this animal jumped over the barrier was your problem.
you're watching Supreme Justice with Judge Karen. We're back with the case of Raphael McGee, who is suing Ashley Winfield for breach of contract.
You should have protected yourself better than you protected yourself. And you said you had $5,000 into this. Well, this was $820. If you could find $5,000, you can find another $820.
Well, it's about I have to retake the whole shoot again. I can't use her pictures anymore.
Right? Do you want to use her anymore?
I don't want to use her anymore.
Oh, so you're through with her too?
I'm through with her.
Okay. Well, so those are your pictures now. Because you sent them in the form you sent them to her. Once you sent them, you disseminated the information like that, then it was a free-for-all. You put it in the public domain like that.
I didn't put them in the public domain. I gave them to a
Email
private email.
is public. Once you send an email, even with a lawyer sends an email, there is a disclaimer on the email that all images and content contained in this email shall be confidential. Was that in your email? I doubt it.
But it was in the contract.
No, an email.
Can I say something?
No, shut up when you're ahead.
I'm sorry.
Why don't people realize, are you losing?
But I
if
have
you're
another
not
thing.
losing, hush.
Okay, but I do have a really great thing to say.
Let me hear your great thing that you
He tried to take naked pictures of me, and
What?
it was just totally creepy and uncomfortable.
That's not true at
and
all.
And here it says that, you know, it's no pornographic or slanderous pictures.
You know, I have no idea what she's talking about.
Where did you say you found this girl? Where'd
In
you
fact,
find
she is a mutual
Where'd you
mutual
find
friend of
her?
ours. You know, brought me to her. I'm never going to use her again because I have no idea what she's
Right.
talking.
And like
You
I
see
said-
the pictures.
Like I told you, excuse me,
so lying.
excuse me. Like I told you to shut up when you were ahead.
Okay.
You were ahead. You kind of went back a couple of steps with
I'm
that one.
sorry.
Because it was totally irrelevant to this discussion.
Okay, you're right. I'm very sorry.
Because you didn't put a disclaimer with those email images and you didn't put a watermark, you suffered the risk that they would end up in the public domain, and they did.
It's
So
the
you
risk-
have to start over again. Judgment for the defendant. Good luck to you both.
All right.
Judge Karen has ruled in favor of the defendant. The plaintiff's claim is denied.
You broke our agreement and it cost me a lot of money.
Well, that's not what the judge thought. Case dismissed.
Coming up,
You tell me that this animal actually jumped over the fence.
Yes. Yes, sir.
That's what I have a problem with.
But I told him only play at this certain time. You can't play
you
at these
know
other
what?
times.
I don't care if there was a 50-string orchestra playing.
this has been a production of Entertainment Studios.